Let's turn it down a little bit. Let y'all get in before we start jamming. Peace, peace, peace. Today, I'm going to be talking about your private rights and the enforcement of your rights. Okay, and this is something that it took me a little while to kind of grasp when I first started learning all this information as well. And it also will explain um, why I'm always talking about the administrative process. Okay, the first thing, let me hit you with a few basic principles. Okay, there is a maxim of law in there's a maxim of law in the Black's Law Dictionary. You get in the back of Black's Law Dictionary, you get like an eighth edition, ninth edition, seventh edition, 10th edition, and you'll see in the back, you'll see these maxims of law. Okay, well, one of the maxims that you have to understand is that the spoken word flies out the window and the written word remains forever. And also from the 10 commercial maxims of law, for a matter to be resolved, it must be expressed. Okay, so letters are contracts. I want y'all to understand that. So when like an attorney, like say when you're going through a foreclosure, and the attorney sends you a letter and he lets you know this is a debt collection. If you don't answer within the specified time, it's going to be presumed. It's a presumption that this debt is valid. It's going to be presumed that this debt is valid. All right. It's a presumption. It's an operational presumption. There's a presumption that the debt is valid. All right, now, I heard someone say one time there's no such thing as debt, there's only the presumption of debt, which of course it has to be true because there isn't any money and the banks didn't really loan you anything. So that's a true statement. When you get into the accounting of all this, you know, everything is based off of a presumption. And this is also the reason why when third party debt collectors, they don't have any inherent right to collect anything. And 70 to 80% of what they collect is solely off of summary judgments because an individual did not answer the letter. When they send you a letter, say you owe us this money, you got to answer within a certain amount of time. You don't answer, they just go right into court and judge didn't answer. Okay, it's a default judgment, and then they just get the money. Now you have a lien against you, and now somebody is taking money out of your check or something like that based off the fact that you did not show up to court. And that's like 70 to 80% of debt collectors. That's how they get off. It's a big money maker for them, and it's a shame because it shouldn't be. It should be the least money maker for them. As a matter of fact, when I used to help people with third-party debt collecting, that would be some of the easiest stuff I would do because off the bat, a third-party debt collector falls under the consumer protection laws under the 15 USC 1692G and the verification of debt. You need to know that verification means that they have to provide some sort of affidavit attesting to the fact that they are indeed a creditor and they are owed some sort of obligation to you. All right, but what I want you to understand is when you conduct an administrative process, what it is and what's happening is that you're creating a contract situation. All right, this is the reason why you send it certified mail, and this is also the reason why you have a notary send it. Now, when you do a administrative process, you never send it yourself. Now, you can send it yourself. I'm not going to say you can't. All right, but the preferred and most powerful way to send it is to have a witness send it, like a notary. That's a witness. Okay, the notary is only there to attest that something was mailed and what the contents of the correspondence were. She's not there to get into any legalities of what you're doing or anything like that. You don't involve her in none of that. All she's there to do is to witness that something got put in an envelope, you know what it was regarding, and it got mailed to a specified address. And she's the one going to do the mailing because she also has to be a witness that nothing got mailed back. Okay, this is why you always have a notary. If you look in creditors and their bonds at all those templates that they have on there, you'll see every last one of them are mailed from a notary. They're not mailed from you. All right. Now we are utilizing a doctrine called silence is acquiescence. You know, if you fail to respond, then you agree with the contents of the correspondence and you adopt them. All right, that's what's being utilized as well. But we're creating a contract. It's an agreement. I read this. It was one of the most powerful things I've ever read, and it was in a military manual where they were talking about civilians' lack of understanding of rights, lack of understanding of rights. In the Constitution, we got probably about the major right that is protected in the Constitution that we possess is the right to contract unlimited. It ain't freedom of speech. It ain't possessing a gun, because all those things can be contracted away. You can actually waive all those rights through a contract. You can give them up by signing your name on a piece of paper and giving them up. So the most biggest and most important right that you have is a private right to contract unlimited. You have the capacity to contract unlimited, and that could be a blessing or a curse, because your ability to contract unlimited can be used against you. You also have to understand that there are verbal contracts, implied contracts, and written contracts. All right. You got to understand there are different types of contracts. You got to study contract. You ought to get a nice understanding of contract law. Do a little study on contract law. Probably wouldn't hurt you to get that. But understand that when you do your administrative process, those constitute contracts. You're creating an agreement of the parties. This this also means that you got to understand how the court system works, because a lot of people are under the mistaken impression that just because they sign an affidavit, then that is like truth. Like that's the truth, the whole truth, and nothing but the truth. Nothing can be further than the truth. Okay, or it constitutes some sort of facts. Okay, an unrebutted affidavit becomes fact in law. Unrebutted, an unrebutted affidavit becomes fact in law. Because what? Silence is acquiescence. There's an agreement. Okay, so we are looking to get agreements. Okay, there has to be an agreement of the parties. You got to know in law what constitutes a fact. A fact in law is a stipulation. It's when both sides agree on the same thing. If I say the sky is purple and you agree that the sky is purple, we can both take that into court, and that is a fact because we both agreed on it. But if I say the sky is blue and you say the sky is purple, that's a material issue of fact. Then we have to go before a fact trier. Okay, a trier of facts. That is usually a judge sitting on a bench, what they call a bench trial, or a jury trial. Okay, there is an argument. Before you go to law, we have to establish what the facts are. This is the reason that you are doing an administrative process in the spirit of Matthew 5:25, where it says, agree with your adversary while you're on the way to court with him, lest he hand you over to the judge hand you over to the bailiff, and the bailiff cast you into prison. I tell you, you will not come out until you pay the very last penny. Farthing means penny. All right, so understand that. Understand that the administrative process is creating a contract situation that you can take into court. This is why it is so important that you document. Everything is about documentation. Okay, so the first step, okay, let's say you discharge in a debt. All right, well, you're going to do a notice of acceptance. You know, I've accepted this presentment, and look up the word definition of presentment, the commercial definition of it. Okay, not the presentment utilized in the Constitution. Presentment in commercial law means that someone is presenting something, a negotiable instrument for acceptance. So you've accepted that presentment. In return, you're utilizing your exemption. Your exemption is your closed account. Okay, your closed account is your social security number without dashes. A lot of you have probably been into this sometime, and you've noticed that people write acceptance for value at a 45-degree angle on paperwork. And you've always wondered, well, why do I have to write my social security number without dashes, or I'm writing it with dashes? When you write your social security number with dashes, that's an open credits. All right. But a closed account is closed for debits and credits, but remains open for adjustment and set off. Once again, you need to look up the definition of closed account. It's under accounts under a Black's Law Dictionary. Understand what a closed account is. So the social security number represents your exemption. It is the only number in the public that represents your straw man. It also represents all your property in the public. All right. So we're letting them know, and this is why you can fill out a form 524 and send it in to the Social Security Administration. And people say, "Well, didn't I, rescind the Social Security number?" You don't. Accounts never go anywhere. When you close an account, all the Social Security Administration is going to tell you from that point is that you have to stop using it. And they're going to monitor you very closely to ensure that you're not using that Social Security number anymore, which is very difficult to do in today's society where everybody's requesting your Social Security number for almost each and everything. So understand that. Okay, understand. All right, that when you write your Social Security number without dashes, that represents a closed account. And when you write it with dashes, that represents an open account. So now we can also go and look at these little acceptance for value stamps, and you can work real closely. And somebody said, well, write your Social Security number with dashes. No, that's a person that doesn't know what they're doing. You don't write your Social Security number with dashes. All right, you write your Social Security number without dashes. All right. All right, want to make sure that we understand that. We got to make sure we got a good understanding of that. Okay. Your exemption, okay, it's called an exemption. What is an exemption? An exemption represents your promise of HGR 182 of June 5th, 1933, that the government would discharge all debts dollar for dollar. Okay, this is the secret that they don't want anybody to know, based off the fact that they took the gold out of circulation in 1933. Now, this really wasn't for private citizens. This was only for people in the public. The government had no authority, and this is why it's important that you understand the distinction between public and private. Because if you had a finely tuned understanding of that, you would know that no executive order could require private citizens to turn over their gold. So they're looking at it that you did it kind of voluntarily, though they'll never probably admit that. But in order for this to not be a fraud committed against the American people, they had to give you something in return. This is like what a constructive trust is, a constructive trust in equity. So that gold is being held in trust, and there has to be an expectation of return of that gold to the American people. Instead of the return of that gold, they have allowed us to discharge our debts and obligations utilizing private commercial script, otherwise known as Federal Reserve notes. Now, these Federal Reserve notes, of course, are operating in a private jurisdiction. A lot of people will tell you that Federal Reserve notes are unconstitutional. This is due to the fact of their lack of understanding of how the Constitution is put together. Okay, this is a territorial jurisdiction. Federal Reserve is operating in a territorial jurisdiction. All right, and that's why you have a federal. It's a federal. It's a Federal Reserve districts. They've created a private jurisdictions, and you have a Federal Reserve Act. They've contracted with Article 1 of the legislature, which is Congress, and now that's why they put together these banking. All these banking associations are members. They're member branches of this private organization. This is what you got to understand. This is why you need a Social Security number. This is why they're always asking you for a Social Security number for everything, because you have to have proof that you are a United States citizen, all right, which is evidenced by your Social Security number, and that allows you to operate in that private territorial jurisdiction of Congress. Now, that is also the reason why you're sending information to the Treasury Department, because you're putting them on notice. Everything we do is notices. You're putting them on notice that you're going to be utilizing your account for set-off purposes, and you expect them to honor HGR 192 of June 5th, 1933, Public Law 73-10, and all associated policies. You're giving them a bond. The windfall of any interest or any investments of that bond is going to go are fiduciaries, and fiduciaries have to receive some sort of remuneration for their services or payment, money. All right. So understand all these things. Once you start getting into this, you understand that what you're doing in essence is private banking. You're setting up a private banking account. There isn't any money. Everybody's using debt paper. You as well can use debt paper. However, you have to have permission to use debt paper in a private jurisdiction. That's why a lot of people get in trouble, because they think they can just arbitrarily and capriciously start putting together promissory notes and without doing any type of secure party process or anything like that, and just start shooting instruments to someone. That's why step one of our process is that we notice the federal government and give them 30 days to rebut anything that we're saying. All right, we're letting them know this is what our intentions are. All right, that way we negate any accusations about mens rea or criminal intent. We told you what we were going to do. We gave you a list of the negotiable instruments we'll be utilizing along with all those numbers. All right, we informed you how we would be routing those instruments, and we gave you an opportunity to rebut anything that we were doing by demonstrating in law how we did not have the authority to do what we're doing. A lot of times the government they bankrupt, they debtors, beggars can't be choosy. Hell, they get all excited when you give them a bond. All right, you write your signature on anything, everybody gets excited because that has value. It has commercial value because a living, breathing man or woman capable of performing labor as guaranteed is act as a guarantor or a surety on an obligation. I hope I'm not losing nobody. I'm looking for uh the comments. Comments ain't on here, y'all, so I don't see them. So, but anyway, I want you to understand that your rights are in contract. They're in contract. They're in contracts. You have to have a contract. You have to create a contract. So what we're doing is when we're writing someone, let's say when you're discharging a debt, okay, and you need to think about UCC 3-603B, all right, which tender a payment, okay. The reason you have a UCC 3-603B because there isn't any money. Because if they will not accept a negotiable instrument, there is nothing else that you can give someone to satisfy a debt. All right, because everything that's operating in this system is a negotiable instrument. Federal Reserve notes are negotiable instruments. Bills of exchange, promissory notes, the bonds, these are all debt instruments. These are all evidences of debt. These are all IOUs. And no way can they be actual payment of an obligation. All right, payment. So this is why we're using accounting or money of account, and we're doing accounting procedures and where we're offsetting debt with one obligation with another obligation. If you owe me $500 and then you come and I come over your house and knock over your lamp, and it was a $500 lamp, now I owe you $500. All right, now we can set off. That's what we're doing with the federal government. Setting off. We're not paying anything. The federal government is bankrupt. They're over 30 debt. They took gold from the American people, so they owe a debt to us. We're using the value of that debt that they owe to us in the private, all right, and utilizing the straw man as a transmitting utility, a bridge, if you will, from the private into the public, and using private credit to offset public obligations by utilizing our signature as the authorized representative for the straw man. Damn, I can't even see it. Okay, I don't know if I can't see nothing. But anyway, I wanted to just drop that on you real quick. I'm not going to talk long today. I want to answer some questions, but I'm driving. I can't really answer any questions right now. Perhaps we can get in some Q&A later. But I wanted to drop this on you that your rights are in contract. Letters are contract. When you do an administrative process, you're creating a contract situation, and now you're going to go into a court of equity to enforce that contract. Equity is fairness, impartiality, and even-handed dealing. And remember, the creator of the balanced universe judges you with equity. Peace to the guys. I'll catch y'all on the next one.